Ms. Karen Dongo, did you need to speak to your client at all before I call the case?
No, Your Honor, I've met with her multiple times. I saw her this morning too.
Okay, very good. Calling People versus Kelly Marie Bryant, case number 250216FY.
Good afternoon, Your Honor. Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Karen Dongo, up here on behalf and with Kelly Bryant. Your Honor, she's present from the Oakland County Jail via Zoom. We have no objection to Zoom.
Ms. Bryant, can you state your name for the record, please?
Kelly Bryant.
Okay. Is that Ms. Bryant's hand in front of her face? Right now? Okay, thank you. This is the time and date set for a probable cause conference on the 3 counts of first-degree child abuse. Ms. Karen Dongo, how did you want to proceed?
Your Honor, I've had extensive conversations with Ms. Bryant as well as with Ms. Ferenczi. At this time, I'm in receipt of, I want to call it partial discovery. I have the written initial police report, which is, there's apparently a supplement that will be available for me today. And also I have the children's interviews. I was provided with those yesterday. I don't have anything else. There are terabytes of electronic discovery that is going to be provided to me on the external hard drive that I provided to the prosecutor's office. So we're asking you to adjourn the probable cause conference so we can have all the discovery. I think it's paramount in this case, Your Honor.
All right. Can you pull something off the printer, please? Thank you. All right. And you discussed the 21 days with Ms. Bryant.
I did, Your Honor. She understands that she has a right to have her preliminary examination within 21 days. It's impossible in this case if we're going to provide her with effective assistance of counsel, and I think she understands and appreciates that. Our next court date would be set outside of that. She's not waiving her right to the preliminary examination just to have it, I guess, at this time within the next week, and she's in agreement, Your Honor.
All right, thank you. I will note that the 21 days is waived, not the right to the exam, but the right to have it within 21 days. I understand that there are still discovery issues pending. Before we get to the date, the defense did file a couple of motions, and I will deal with those this afternoon as well. One was a motion to restrain pretrial publicity. I did receive and review the motion as well as the briefs. Any comment from either side as to that?
Your Honor, just ever so briefly in response to some of the things that the people were putting in their response or their objection to my motion. You know, there's a lot of information that's already public information, meaning the court proceedings are open to anyone, certainly to the media. There's the register of actions that are public. There's a lot of public information. There's also already a lot of information that's been disseminated via social media and the Oakland County Prosecutor's Office. The issue I'm having is that the Oakland County Prosecutor's Office disseminated information that really is confidential information that they have had me sign a protective order for before I could receive it, which included the children's interview. They also requested initially that I sign an agreement to not disseminate anything of discovery nature to anyone, including my client. And I declined to sign that. But so they've asked me basically to not talk about this case or share it with anyone. But at the same time, it's saying that this is in the public interest. I don't think it's in the public interest to disseminate evidence that hasn't been admitted into court. And I don't think it's in the children's interest to disseminate any of that. The public can certainly be kept informed via the media when we have court proceedings, as well as, you know, what the public can look up on the public register of actions from court. So I don't see any public interest in the prosecutor's office continuing to hold press conferences and talk about this case, and, you know, including the Oakland County Sheriff's Office, which, you know, many of those deputies and detectives are assigned to this case. They're witnesses in this case. And the Oakland County Sheriff's Office continue to talk to the public about this case. I was especially disturbed by the fact that what looks to be a body cam from one of the deputies that were in the home has been disseminated all over social media before we've even had any kind of court proceeding. So I do think it's a proper motion. I'm asking that you grant it.
All right, Ms. Ferenczi?
Thank you, Your Honor. I do just want to respond briefly to both Ms. Karen Dongo's statements today and also her motion. I do want to be clear. Oakland County Prosecutor Karen McDonald held one press conference on February 19, 2025, after Ms. Bryant was formally charged. In that press conference, Prosecutor McDonald combined her statements to the already public information from the swear to that morning. Prosecutor McDonald has not made any public statements about this case that has any potential to deny Ms. Bryant her constitutional rights. The statement about the video, I am not aware of what video Ms. Karen Donald is speaking of. From my understanding, we live in a social media era right now, and information and misinformation spreads very quickly. We did get reports that individuals in our community, not part of law enforcement, made unauthorized entry of the residents at issue in this case, and did record videos, take photographs, and posted their findings on social media that did have high views. And Your Honor, that vigilante activity does create a dangerous precedent and the potential of widespread distribution of misinformation. And Your Honor, I do believe that a gag order would prevent the prosecutor the ability to correct any sort of misinformation. This case has drawn a lot of public outcry, and a lot of that public outcry predated law enforcement's presentation of this case to the Oakland County Prosecutor's Office requesting charges. And the reason of that outcry is because the welfare of our community's children is a vital social concern. And the facts of this case squarely involve allegations of egregious harm to children. And Prosecutor McDonald has a duty to comply with the Michigan Rules of Professional Conduct. MRPC 3.6 and 3.8 expressly recognize that the public has an interest in and a right to know about cases as such. Prosecutor was acting within her authority and in good faith in making already public statements during the February 19th press conference. The issues that Ms. Karen Dongo brings up about this misinformation is the sole reason why it is important for the prosecutor's office to be able to check the misinformation and provide accurate information of what is happening in this case. The public has a right to be precisely and accurately informed about its vital social interests in the systems that are responsible for keeping our children safe, Your Honor. And I respectfully request on behalf of the victims and the citizens of Oakland County that the court deny the defendant's motion, Your Honor. Thank you.
As I indicated, I did review both the motion and the briefs that were attached. And the court did review MCR 8.116D1 to evaluate whether a restriction on information or a gag order prohibiting discussion of the case with the media, whether that would be appropriate. And as you're all aware, the Michigan Court of Appeals has indicated that an overbroad or vague gag order constitutes a prior restraint on freedom of speech, freedom of expression, and freedom of the press. So this court would have to determine that the interest to be protected outweighs the right of access. Denial of access would have to be narrowly tailored to accommodate the interest to be protected, listing the specific reasons for limiting access. The initial charges against the defendant have already been presented. The prosecutor has held a press conference which was prior to the date of the arraignment. We are now at the probable cause stage, so it would appear that there should be no further need for such similar press conferences during the pendency of the case. A gag order, in this court's opinion, would be inconsistent with law, Michigan Rules of Professional Conduct, and the public interest. The Michigan Rules of Professional Conduct do provide guidance in this area, and those rules do permit a prosecutor to make statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. The February 19th press conference that was referenced in the motion and the response was actually prior to the arraignment, which was February 20th. Now, massive, pervasive, and prejudicial publicity has been ruled in cases to interfere with an individual's right to a fair trial, but the mere existence of pretrial publicity does not automatically deprive the defendant or the prosecution of a fair trial. There are court rules and jury instructions that can provide protection in these areas. So while this court will not be imposing a gag order, I'm simply instructing the parties to comply with Michigan rules of professional conduct and court rules during the pendency of this case. But should there come a point, while this case is within the jurisdiction of the district court where there's a massive, pervasive, and prejudicial round of publicity, this court will review the issue and make the appropriate determination at that time. At present, defendant's motion to restrain pretrial publicity is denied. Now, the defendant has been charged with 3 counts of first-degree child abuse, which carries a maximum penalty of life. The defendant is still, however, presumed innocent until proven guilty, and that brings us to defendant's next motion, which was a motion for reasonable bond. I did, for the record, have a brief bench conference with both attorneys as to that motion. And the court is willing to do an evaluation of appropriate pretrial release conditions. The things that the court has to consider is the defendant's prior criminal record, if any record of appearance or non-appearance or flight to avoid prosecution, any history of substance abuse or addiction, the defendant's mental condition, including character and reputation for being dangerous, the seriousness of the offense charged and the probability of conviction and likely sentence, any employment history, status, and financial history as they relate to the ability to post bail, the availability of a responsible member or members of the community who would vouch for and monitor the defendant if released, ties to the community, including family ties and relationships, and the length of residence, and any other facts bearing on the appearance or danger to the public. So the standard at this point is not abuse of discretion, but the court is willing to review the issues related to pretrial release in detail. We would not be able to do that today because of the other cases that are scheduled. However, if both parties are available, I am willing to do that on Friday so we don't have an unnecessary delay. I do understand that we will have to adjourn the probable cause conference. Will this Friday at noon work for both parties?
Yes, Your Honor.
Yes, Your Honor.
That will be on at noon, and that will be the motion for a reasonable bond, where the court will review it and make specific findings as to that. In the meantime, I've noted the 21 days is waived. We'll set the adjourned probable cause conference to Tuesday, April 15th. That will be at 2 p.m. For today's purposes, bond will be continued, but I will address it on Friday.
Thank you, Your Honor.
All right, anything else for the record on this case today?
Your Honor, will the motion hearing be held via Zoom?
It will be via Zoom, yes.
Thank you.
All right.
Thank you.
Thank you. You're all set. Bond is continued for today. Thank you.